Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. Today in this video, I am going to discuss with the certain short notes concerning the international law, which are important for the examination point of view. Today in this video, I am going to discuss with first short note, that is on intervention. Every state has a right to manage its affairs, internal as well as external, according to their choice. And this right has been guaranteed by the principle of state sovereignty. At the same time, a corresponding duty has been imposed on each state of non-interference. Thus, the non-interference, that is the affairs of other state, that is an established principle of international law. So, when there is violation of this principle of non-interference, or we can say that when a state intervenes in the affairs of another state, that is termed as intervention. According to Professor Oppenheim, in the intervention that is forcible or dictatorial interference by the state in the affairs of the another state. There are the certain essential elements for intervention. That is, number one, intervention that is always forcible or dictatorial. Intervention is always done without the consent of the state. There is always dictatorial interference, which is different from the interference which is pure and simple. According to Professor Oppenheim, intervention that is pure and simple, that is not intervention. Intervention concerns the external interdependence or the territorial or personal supremacy of the state concerned. Thus, the intervention may be in the internal and external affairs of the another state, either directly or indirectly. Thus, the purpose of the interference, that is to compel the state to do which intervening state does not want to do, or not to do which it want to do. So these are the certain essential elements for the intervention. If we talk about the intervention by the invitation or on request, when a state interferes at the request of another state or with the consent of the state, which may be given in advance by the treaty, that is not intervention. But it is essential that the request for the intervention should be made by the government of the state. If we talk about the intervention, that may be of certain kinds. Intervention may be either military, that may be persuasive, that may be subversive, economic, or diplomatic. There are the certain kinds of intervention. First one is military, second one is subversive, and third one is economic, and last one is diplomatic. If we talk about the military intervention, it takes place with the use of armed forces. Second one is subversive intervention. It notes the propaganda or the other activities by one state with the intervention of something for its own purposes, revolt or the civil strike in another state. And third one is economic intervention. Intervention with the trade and shipping and denial of access by the land on water. These are the economic intervention. And the last one is diplomatic intervention. It may include the communication of threatening tone, implying the possible use of military or other coercive means or measures. If we talk about the justification of the intervention, whether the intervention is lawful or not, it is a matter of debate. In this regard, there are different views of different authors, and some are of the view that the intervention may be justified on certain grounds, while the others are of the view that it is an unlawful act in all the cases. The Security Council has empowered to use the force in accordance with the provisions of United Nations Charter. Thus, intervention may take place by the state individually as well as collectively under the authority of the Security Council. Here, the justification of the intervention that is discussed under the intervention by a state, that is individual intervention. Legality of the intervention has been affirmed by the International Court of Justice in the Curfew Channel case by stating that the intervention in the interference, that is internal or external affairs of the another state with a view to compelling the another state to do or refrain from doing certain things has long been condemned, has been expressly forbidden by the Charter. Also, the International Court of Justice has observed that the non-intervention, that is a part and parcel of the customary international law. So this was all about the intervention. Second note, that is on the blockade. When the coast of enemy is blocked by the belligerent country in such a way that there may not be any movement of vessels from and to the coast, the operation that is called blockade. According to Professor J.G. Stark, blockade occurs when a belligerent bars access to the enemy coast or part of it for the purpose of preventing the ingress and egress of the vessels or aircrafts of all the nations. According to Professor Oppenheim, the blockade the blocking by men of war of the approach of the enemy coast or a part of it for the purpose of preventing ingress and egress of the vessels or aircrafts of all the nations, that is called blockade. There are certain essential elements that must satisfy with the blockade. This means essential elements that legally operate blockade are the number one, blockade is done by men of war. That is essential. It is an act of war. It is applied during the time of war. Thus, the blockade is different from the pacific blockade, which is a coercive means of settlement of dispute. An element that is blockade is applied to the vessels of all the nations, including the vessels of the neutral states. That is, according to Article 5 of the Declaration of London, laid down that the blockade must be applied impartially to the vessels of all the nations. Here, the term impartiality does not mean universally. So, the belligerent has liberty to decide the blockade shall not be applied to a particular neutral state. So, the belligerent has liberty to decide the blockade shall not be applied to a particular neutral. If the belligerent includes a vessel of state from the application of blockade, then it will issue a license to such vessels. And the third element, that is blockade, applied in the coast or a part of coast of the enemy state. Before application of the blockade, the state should see that the interest of third parties should not be affected. And the fourth element, that is the purpose of the blockade, is to prevent the ingress and egress of the ships. It is not necessary that both the ingress and egress should be prevented in all the cases. Sometimes only ingress or sometimes only egress may be prevented. In such cases, the blockade inward and blockade outward is referred respectively. Blockade inward is applied so as to prevent the supplies from the other countries to the enemy state. If we talk about the law on blockade, during the London Naval Conference, a detailed classification of the law on blockade was achieved, which includes 21 provisions on the blockade in times of war. But this declaration was not formally notified and was accepted as a general principle or the existing law on the blockade. If we talk about the establishment of the blockade, before applying the blockade, two conditions are required to be fulfilled. Number one, that is declaration and notification of the blockade should be done. On the outbreak of war, blockade does not come into being ipso facto. It has to be declared and notified to the neutral states. For instance, the declaration of blockade may be made either by the blocking state or by the naval authorities. So it must specify the beginning state, coastal limit affected, and several days of grace for exit. Second, that is effectiveness of blockade. Here the effectiveness means it applied with the sufficient force. The state is able to capture the vessels attempting to ingress and egress the coast. So the blockade. In case of, if we talk about the violation of the blockade is unpermitted ingress or egress of the vessels in spite of blocking. In a vessel having knowledge about the blockade and without the license or excuse either enters or leaves the blocked part by forbidden way. Breach of blockade is a criminal act. A vessel making an attempt to breach or break the blockade or a vessel which has committed a breach of blockade may be captured along with the cargo. The crew may be detained for the time being as they are required to serve as witness before the prize court, which would determine the validity of the captured vessel or its cargo. If we talk about the end of blockade, it can be ended in the certain ways. Number one, when the state has establishing the blockade withdraws it. Second, when the war comes to an end. Third one is when the enemy forces have driven off the blocking squadron or fleet. It occurs when the blockade is not effective. And the fourth one is when the state establishing the blockade is defeated in their war, whose coast has been blocked. This was all about the intervention and blockade. These are the certain short notes which may be asked in the coming exam. If you have any doubt, you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.